Welcome to Manage Your Risk, a panel discussion with experts in the field of risk management. When we see FEMA in action, it is dealing with risk after an event. We don't see what they do to prepare before an event. In your business, there are things you do before something happens and things you do after. You can avoid, mitigate, transfer, accept, share, plan, and exploit. Now, I'm Paul Menig, CEO of Business Accelerants. As a business coach, I focus on privately held, small and medium manufacturing, technology, and transportation businesses. I have a multitude of tools and processes to help them rev up their business with consistent growth in revenue, earnings, and value. Blaine, please introduce yourself.
Thank you, Paul. Blaine Cluton. I'm an attorney. I have a sales background that I now apply to litigation. My primary practice areas are personal injury. I do family law, estate planning, but I'm also a general practitioner. I'm also a judge, and I have experience as a presiding judge. I also do arbitration mediation. Thanks, Paul.
Okay, Ryan?
Thank you. And thanks everyone for joining the call. My name's Ryan Fairdy. I'm a commercial insurance broker with Brown & Brown, and I'm part of our National Policy Resilience Analysis team. And what that means is I read insurance policies like crime novels, line by line. I look for what could go wrong, and then I help business owners make sure that their coverage actually fits the risk they face today, not just what they signed up for years ago. When I'm not doing that, I do a lot of volunteer work with my 120-pound therapy dog, Higgy, and I'm excited for our conversation today.
Martin, introduce yourself.
Thanks, Paul. I'm Martin Medeiros. I too am an attorney. I've been practicing for 30 years, primarily business transactions, intellectual property technology, but I also, for 25 years, have been teaching a negotiation course. I currently teach it every second Tuesday and fourth Tuesday every month. It's called the Negotiation Dojo, where a lot of the practical side of how to negotiate is what I do, and it's not theoretical. I do read all the papers, and I have an award-winning podcast called The Persuasion Lab, and I've learned a lot from neuroscientists, psychologists, hostage negotiators. You can check out that podcast if you want to know from them, but it's a practical approach to negotiation.
Okay, thank you, all three of you. I appreciate that. I've put some of the questions that we have into some categories, and so in my business, at least, I often encourage people to start with the end in mind. And so, looking at some of the questions you provided, Blaine, I'll turn to you first. One of the questions you suggested is, why do I need to be thinking about litigation when I'm drafting a contract?
And one of the things that we're looking at in this question is whether or not we should be considering the drafting of the contract to avoid litigation, and what aspect litigation is going to play in contract formation and then litigation later. So when we're looking at drafting tips to avoid litigation in the first place, we would be looking at 5 different areas. One is remedies, which is going to be in the damages context. And then we want to keep in mind that damages are going to be a two-way street. 2, dispute resolution, early resolution. 3, attorney fees, and that's a double-edged sword. 4, early communication when the relationship is still positive. And 5 is to avoid decision layers so that you're identifying the decision maker early in the contract process. And the reason that you want to be thinking about all of these things up front is you want to anticipate that if something's going to go wrong, you have contemplated all these potential pitfalls. So that's kind of how I generally structure that response.
Okay, thanks, Blaine. Ryan, you said, looking at toward the potential end again, what's the most overlooked risk that successful business owners don't see coming?
Yeah, thank you, Paul. So I think that the biggest risk that business owners don't see coming is really does their insurance program still fit their business? Oftentimes, I see that companies have outgrown even the insurance purchasing model that they've assumed. Maybe they can be taking on more risk to receive a higher financial upside because of the controls they have in place. Maybe they have um, properties and other exposures listed on their programs that they've long since stopped using, which is going to result in a higher premium. Or maybe they've brought things onto their policy that they aren't actually or appropriately insuring. And so these types of things really leave a business owner open to risk because they're going to sleep at night thinking that they have a policy that protects what their business is. And in reality, the policy may be written or structured for effectively a different business as they've grown.
Yeah, just as an aside, just before this started, I got my renewal notice for my home insurance and was shocked at the number that was on it. I forget that I pay it monthly. And Blaine, to your point, I see a lot of businesses with partners and they haven't allowed for the possibility that they're going to argue later about how to get out of that contract and don't have the right terms in there. So, Martin, another thing that is especially important to a lot of people is intellectual property. So, what are the most effective strategies for protecting intellectual property?
That's a great question. I hate this is the most unsatisfactory answer any attorney will give you, and that is it depends, right? So it depends on the situation. If it's like sole proprietorship, you have to, different things vary. For example, a term for like copyright ownership is 70 years plus the life of the author. So if you're looking for intergenerational wealth, you may want to hold that copyright personally. Corporate copyrights last for 100 years flat. So life of the author, average age, I think, is 74 for males in the US, plus 70 years. That's potentially 114 years, I guess. Is that right?
Close
144?
enough.
Something like that. Years of potential wealth growth. And it all depends. A lot of companies today are using a holding company model whereby the holding company will hold the IP assets and license back to the subsidiaries depending on where they are. Patents are available for 20 years, 20-year monopoly, but it'll take you, on a good day, 5 years to get a patent. There are different time frames, but trade secrets are the most important. And this is probably the highest risk area people neglect, especially in an NDA. Trade secrets have that protection as long as you comply with the Uniform Trade Secrets Act in most states and the Defend Trade Secrets Act on the federal level. And what that means is you have to keep the secret secret. It has to have a value and it has to give you a competitive advantage. So those are the broad brush 3 requirements. I have been in federal court where we could not produce evidence that we or my client continuously had people sign NDAs and could point to, oh yeah, that stuff, that's my trade secret. What are trade secrets for small businesses? Definitely your customer list, your vendor lists, all the, say you have a newsletter, all the IP in that newsletter, the content there. If you have a podcast, of course, that's copywritten material. So protecting that IP will reduce risk as to your competitors. And that's the biggest thing. Certainly the Trademark Act protects individuals for unfair trade practices, trading on someone else's good name, the Lanham Act. So those are kind of like the catch-all of the 4 big buckets of intellectual property: copyright, trade secret, trademark, and patent.
On copyright, you'd no longer, by law, as I understand it, have to put copyright on your slides and on your documents and things. But do you recommend that they do anyway?
Yes. So according to the convention, it used to be you have to put the C, but internationally we're party to conventions where all countries signatories don't have to put that C, but it's important to put it because it will provide notice to the person. And for intentional copyright infringement, the damages are much larger. For intentional copyright infringement, statutory damages. And what that means is I don't have to prove actual damages. How much is a website worth, for example? But I'm allowed to between a minimum of 750 to a maximum of 150K, $150,000 per act of intentional infringement. If you see the C and the name of the person or the company on the bottom of your slide deck and they use it, let's say it's you haven't signed an NDA, you not even an NDA, if it's just affixed intangible form, that's when copyright attaches and the right happens. If you register it within 90 days of publication, when someone else sees it without an NDA, you can get those statutory damages. If you register it after that 90-day period, you're limited to actual damages. How much did you copy my book? How many sales did you make on that book you pirated? That's actual damages. Statutory damages are prohibitive. We don't want people to do this, and we want people to innovate, create plays, and all that. And that's kind of the quick rundown of Section 106.
Right. Well, I'm going to change what I do in my slides then as a result of your recommendations. So this isn't a class on AI, but we do have to touch on it briefly. And so there's two questions. Blaine, can I use AI to write a contract?
So you can, but it would be fraught with peril. And there's four main things that I kind of want to address on this point. The first is that it is still going to be a garbage in, garbage out process. It's becoming more of a common starting point to use AI for contracts. I'm even hearing about big law firms starting with AI to get the bare bones. But once you have, let's say that you're a business practitioner and you're not an attorney and you're trying to draft something, once you've drafted the bare bones of the contract, the purpose of having an attorney review it is like an insurance policy. It's something that Ryan would probably attest to. Anytime that you can add more insurance, it's a good thing. And if you're relying only on yourself and AI to create this contract, that's risky. So let's use a kind of a fourth example. So one of the things that AI likes to do or tries to do is they will take your prompt and try and draft it in such a way that it meets the prompt's requirement, but then it still is in violation of the law or not compliant with law. So we've all heard the story about where AI is citing either bad case law or case law that doesn't exist to make it work. But a more interesting example is where let's just say an architect or an engineer is drafting a contract and they say, remove all my liability. And the AI generates a contract that removes all their fiduciary responsibilities. And they don't have an attorney review it, they sign it. Well, the fact is that under the law, you can't waive certain fiduciary duties and circumstances. So while you think that you've taken these steps to protect yourself and in this contract, you're going to be in for a rude awakening when somebody goes and seeks to enforce this contract and you say, no, we've waived all those things. Well, certain things aren't going to be waivable. And that's why it's good in any context, even if you've used AI as a starting point, to always go and run that by an attorney.
Okay, thank you. So Martin, legal risks, liability for biased outputs from the AI, intellectual property disputes over AI-generated content now, regulatory compliance with emerging AI laws in Europe versus here. I don't know about anything in Asia just yet. How can businesses negotiate contracts or policies to mitigate these risks effectively?
Yeah, risk mitigation, really important. I just want to say, Blaine, he hit it right on the head. AI has low self-esteem. It wants to make you happy. I do cover, it'll answer your prompt, as he said, garbage in, garbage out. So being a good prompt engineer is really a key skill. And how my clients are dealing with risk mitigation. If you have content, say, on your website, I really want and again, I have to give my disclaimer. Nothing I say is legal advice. Talk to your attorney in your jurisdiction. This is just an open, freewheeling discussion. But what I'm telling people is to make sure that in their terms of use and privacy policy that you address AI, and there's ways to do that. For example, if part of the contract you have with the visitors to your website is that they're not gonna use your website for training data, and an AI is owned by a company and it is a visitor to your site and they are subject to the terms of use. If you look at New York Times v. ChatGPT, that's a very interesting case um, based on a lot of contract law on what you can do. And New York Times says, hey, you went behind our paywall and got our reporting, and ChatGPT's counterclaim was, hey, in order to do your complaint against us, in order to get the information that's on that complaint, you had to subvert our website, and that's illegal in our terms of use. So that's a counterclaim. So contract law is part of the AI fight. So if you have what I call good intellectual property hygiene, that's really important. I do a roadshow, AI in the law, 45-minute speech to different groups. And the biggest thing people say is they really don't have a plan or policy on what to do with AI. And right now, that's really not an excuse for anyone. You have to have a plan, you have to have a policy, and you have to do that. And it's really important for what rights are you giving up when you use AI? Let's look in Blaine's example on the AI context. Attorney-client communications are protected. There's a recent case where one client said, hey, I wonder if I have a good attorney. They uploaded the entire contract to AI, and the judge ruled, no more attorney-client privilege. That's public information because that contract is now training data for the AI. And for the right prompt, you could get a lot of the same stuff of that contract, which may deal with trade secrets, licensing policy, buy-sell strategy, a lot of things. So you really have to get informed on AI and the limits of law and how it kind of impacts your organization. And having a plan is where you start.
I like what you said. Basically, I should update my terms of use on my website so that they're not just can't copyright my blog articles and my videos and things, but also that they can't train on them.
Right. So there's some cases where the scraper, the AI scrapes information, use it in their AI to get a result. And this is a privacy law issue. If the scrapee had a hole in their security and allowed the scraper to take personally identifiable information, they could be in violation of GDPR for European Union citizens, or California has a very robust consumer privacy law protection. So even if you're the target, you still have to make sure that everything you put on that website is secure and not subject to any workarounds. And you should, additionally, in those terms of use, no reverse engineering, no workarounds, kind of like what ChatGPT did in their defense in New York Times v. ChatGPT.
Okay. Blaine, were you about to say something?
I was going to point out one more thing and ask Martin maybe to comment on it a little bit, but there are these closed circuit, closed loop AI systems. Yep. And that is a way to protect that data from being transmitted to the public or becoming publicly available. And I just wondered if Martin can comment a little bit more on that.
That's a great point. And, for practitioners, if you have private information, if you have some type of professional relationship where you can't disclose this information, a lot of service providers do have containerized instances of AI engines. For example, CoCounsel, which is owned by Thomson Reuters, has a containerized AI. They actually use Gemini, Google's backend, which I found very interesting. So a lot of these, like Westlaw, which is owned by Thomson Reuters, LexisNexis, they are licensing back-end AI engines from people who perfected the technology after failing at trying to writing their own, but it's containerized. Their training data is only trained on the subscription-based, say, Westlaw database for case law, and in the case of co-counsel, stuff that users can use up. It doesn't use that in the wild woolly world. There are other AIs. One company, I'm not going to mention the company, but they actually use the SEC database, Edgar database, to get contract terms to help draft. Well, for the right prompt, is that confidential? I'm not sure. They're marketed to the legal markets. There are publicly available engines right now that have a privacy mode whereby you can set it to auto destruct every prompt after a certain number of time. And two, they do not use your prompts as training data for the AI. The only one I know who uses that right now is Grok. Others may, but right now, if you do have containerized, if there is a privacy function, if there's an auto, prompt destruction, I think you can reduce your risk in using AI. But if not, don't use it for trade secret development. Don't use it for product development. Within you want to generate ideas, you can generate code and all that stuff. But if it's something really innovative, know that if it's a public prompt, it's going out there, and your competitors, it'll come up in a competitor's prompt at some point if for the right type of prompt.
Okay, Ryan, we're going to turn to you for a couple questions now. I expect that most leaders consider insurance as the main thing that they're going to do, their key to risk management. So if you had 5 minutes with a business owner who's doing 10 to $20 million in revenue, what insurance questions should they be asking themselves and their broker?
Yeah, Paul, that's a really good question. I think a lot of times businesses kind of can fall into a blind spot of trusting their broker, handing off their program, and letting them run with it. But even a business manager or owner who's a little bit more engaged and sees their insurance partner as a partner, that they're building something together, is going to get a lot more out of them and out of their insurance program. So one of the first questions I think that should be asked is, again, does our insurance solution still fit our company? As I talked about before, a company that starts out might have a different risk appetite than they do as they grow and they start looking at the possibility of their insurance being more of a financial tool, assuming more of that risk and assuming more of the control for a financial upside. And if they're not there now, then is that even a conversation that their broker has had with them, that that's even a possibility that they could be building to? There are plenty of companies out there that have really strong risk controls, great financials, and low loss records. And year over year, they're still subject to what's happening in the pooled risk model that they're still in, which is, they do really good and someone else does really bad, and the insurance carrier needs to balance it somewhere so everybody gets an increase the following year. So that's one question. Another one is when I'm non-renewed by my carrier, what's my broker's plan B? I find that it's on this side of the fence as an insurance broker. I see companies get non-renewed all the time. For companies that are out there in the wild, they might not know that that's happening all the time, and that it's only a matter of a market shift somewhere for their insurance carrier to say, this is not an industry I want to be in anymore, or this is not a company I want to insure anymore. It's not ideal, mind you, but it is going to happen. And when it does your broker have a plan B? Is your broker staying in touch with the marketplace and what other carriers might be interested in writing your risk, so that when that change finally does happen, it's just a matter of, oh, we're moving them over here. We've been talking to this other carrier about you for years, not a problem. Or is it going to be a hand grenade that goes off right before renewal, leaving you 30 days to end up with whatever program your broker can scrape together quickly? So those are two of the questions that I would really put forward. And let me see, do I have any other? Yeah, I mean, that's really those are a couple of the bigger questions I just see businesses not asking, and it really has an outcome on their program and on their coverage.
So that would be particularly a case right now in Florida and California, fire risk and hurricane risk, where certain
Yeah.
insurance companies have just decided that's it. That's all the loss we can handle. We're no longer going to insure in those areas.
Yeah, that's it. Well, and especially in the case like Florida and California, what you're seeing is what's called admitted markets, which is all of the insurance companies whose names you can think of. They have to file with the state, and they tell the state this year to make up for last year's losses, we need to add this much of an increase across the board. And the state says, we're not comfortable with you taking 7% increase, but we'd let you take 5. Well, the insurance companies are not nonprofits and they need to make their money back. So the next year they're going to come in and they're going to say, now we need more. And the state says, no, we don't want that. We don't want to be seen as letting you run ramshot over our inhabitants here. And so then eventually what you're seeing in California and Florida is they're taking their ball and they're going home. And what you're left with then is non-admitted markets, which aren't necessarily a bad tool in insurance. They don't have to file their rate increases with the state. But as long as you're with a well-rated carrier, it's you can be in a good position. But in states like Florida, what we're seeing a lot of is kind of more fly-by-nights companies that have lower lower financial ratings and securities, and they're making a deal with you that they're going to cover your house. But when the next monsoon or hurricane or flood comes through and it wipes out all the homes that are on their book, they're going to go bankrupt. And where are you?
Well,
So,
that's when we're going to need Martin's negotiation stuff and Blaine's judge and
well,
contract dispute.
I hate to say it, but on when those situations come up, Martin's already out the door. I hate to say it,
Ooh.
because if you don't negotiate up front, then you don't. I mean, on the back end, it is what is written down, and that is where you need Blaine. And so that's why a smart insurance approach is to ask for everything you can possibly get from the carrier. I mean, they're financially incentivized, and if you were investing in them, you'd want them to do this, to take the maximum amount of premium for the least amount of coverage. And so it takes a sharp eye and a good broker to know the business that they're insuring, to get in there and say, we need coverage here. We need coverage here. We want to expand that coverage to make it the most robust coverage for the least amount of premium. And you can negotiate a lot before there's a fire. Once the toothpaste is out of the tube, no one's talking to you except, a whole different division of the company. And that's where Blaine jumps in.
Okay.
Yeah. And I just want to interject, talk to Ryan early and often, because, and I disagree with me if you want, but there's 2 negotiations he's having, one with his client and one internally with his organization to get you the best policy. I have a soft spot for Ryan because he's a graduate of my negotiation course.
Which I will plug, Martin. That is a fantastic course. I don't know that there's anybody who knows as much about negotiation as Martin. He is a student and a practicer of it. So
Okay, great. So as a follow-up, though, you talked a lot about driving your broker instead of just waiting for renewal. You've talked about what should a smart client be demanding, and there's some other things you talked about with the structure that I don't understand. Product structure of insurance.
So there's just a few things there. Let's start with product structure, and I would love to circle back to driving your broker. So a good rate on a bad policy is a bad policy. It's nobody's good deal. And as Blaine talked about earlier, when you are building a contract, you want to build it as robust as possible. And so oftentimes customers see, apple to apple. I paid $1,000 for my program this year, and now you're telling me it's, $1,100. I don't want it. Someone else is coming in at $9. They all look the same, but they're fundamentally different. You might have lower lines of coverage. You might have different insurance forms that are more exclusive or restrictive. You might have things where your liability becomes broader. And so having a broker who can take a look deep into those and really pull out of a policy, these are all the things that we don't like about it. And these are all the things about what we don't like that fit your business and need to be changed. That is a structure. And so having a good structure is the most important thing, because when you have a loss, you're not going to be high-fiving the rest of your team that you saved $1,000 at renewal time when they won't cover $1 million loss. So that's part of it. And again, that's where Martin's all over the board. That's where you're negotiating with the insurance carriers and you're pushing back. And sometimes it leads to a small increase, but more often than not, they're just happy to close the deal on their end. And, a well-placed negotiation gets a customer a lot more coverage. The driving the broker part, that's kind of back to what I was saying on structure. If you have a broker, let's call them broker A and broker B. Okay. So most people have broker A. There's nothing wrong with them. They send you a birthday card. They answer your call. If you have a question, they're going to answer it for you. No problem. They get you your certifications on time. Everything seems fine. But if they're not actively, again, looking for that second option for you when your carrier is going to cancel you, if they're not negotiating your contracts both at renewal time and well in advance of renewal time, then they're just kind of along for the ride. And we get paid good money, so don't leave that money on the table. Your broker should be coming out probably 90 to 100 days, 120 days in advance of your renewal and talking about where is your business now compared to where it was last year, and where do you want to be next year and in 5 years? Because if we don't build a program for you that's going to grow with you and cover your expanding operations, then one day you're going to wake up and find that something wasn't covered that could have been covered in the conversation, and you're going to be at a gap.
So that brings to mind, banks have covenants, and banks require certain amounts of insurance on certain things in order to do that. So where does your broker with the business owner and the banker all kind of work together?
The banker side of things, not as much. Like, I'm not talking to bankers necessarily, but oftentimes where that would come back into play would be certifications. So one business says to another, if you're going to work with us, you need to have a certain amount of coverage. And so you get a certificate that says, I'm working with Paul Menig, Paul Menig Corp, and Paul has required that I have certain limits here and here. And then that I name Paul on my program so that if something happens, I'm going to cover Paul while we're working together. But the term that we have, or the saying that we have around the office, is big print giveth and small print taketh away. And so this is something both Martin and Blaine can identify with easily, is it says you have it unless it happens on a Tuesday or like when it's 30% moist outside. And so even though you have coverage on paper in the big black ink, when you get down to the small print, it might be a very, very different picture.
Eesh. Okay. So let's turn to negotiation and litigation. They seem to go together to me, from the way you've talked especially. So let's start with Martin. Technology-driven contracts, software development, software as a service agreements. What key clauses should businesses negotiate to limit risks like data breaches, service disruptions, liability for third-party claims? And how do you balance these protections with client demands?
It's a great question, and I have a little PTSD. So I drafted a contract around this subject matter, um, and it went fine. It was actually part of a settlement in a dispute. So it went into mediation, which is like pre-litigation, and we got a settlement, and there was licensing terms and IP transfer and stuff. And it was fine for 7 years until the other party stopped paying. And we ended up in 2-year arbitration over COVID virtually. And I kind of had to win the case because I drafted the damn contract. And we were successful, but I think Blaine hit it on the head. What are your damages? Is there a damage limitation? You see the regular carve outs in any well drafted contract, any consequential damage. For example, I think this is what Hadley v. Baxendale. There's a landmark case where the shaft on a grain mill broke, and the person not only got damages for the defective crank, but also the consequential damages, the other losses that miller had in producing the grain. So that's, I hope I got those facts right. It's been 30 years since I learned that in law school. But long story short is consequential damages have got to be barred. In other words, you have to say that up front, and for UCC Article 2 places, that's be in bold print, big print. Um, Damage limitation is one thing, and when things go sideways, who's going to pay? This means indemnity. Who will step in the shoes of the wrong party and defend them, pay legal fees? And Blaine said it, legal fees, if they're not in that contract, judges like Blaine are not going to award it if it's not part of the deal, if legal fees are not part of the deal. And he said it's a two-edged sword, totally true. If you have nothing to lose, you probably want a legal fees clause, like a bigger company and it's a smaller one. If you're a smaller company, you may want to think about, well, if I lose, do I want to pay, Fortune 500 companies legal fees if I lose? So these are kind of decisions you have to think about, relative risk and what your damages are. So talk to your attorney. It's a very dynamic situation in negotiating and anticipating litigation. Great statistics. If you have a business succession plan, you have less disputes. If you have a robust operating agreement, if you're an LLC, you have less disputes. If you have a prenuptial agreement, you are more likely to stay married. So getting things in writing, I can't emphasize it enough. And some people can't afford a contract, a fancy lawyer. Do it on a napkin. I don't care. As long as there's something in writing. What I can't prove is he said, she said. What I can't prove is this. I'm almost, and this is not a recommendation, I'm almost more favorable for a bad AI generated contract than zero contract, because when we don't have contracts, quite frankly, every attorney makes a lot of money because we have to say, what is the objective manifestations of the party? Are you making loans? Where's the promissory note? I've had all these cases where there's no paper, and then legal fees go through the roof because you have to prove on people's memory and maybe a text and maybe an email, maybe a social media post. So get it in writing.
Wow. Okay, I'm going to turn to you, Blaine. So let's say we did a bad AI contract, which Martin suggests is better than no contract. So now, Blaine, help me escape from a bad contract. How can I breach a contract and avoid litigation? And what the heck is efficient breach?
So if we're trying, it does take us back to the beginning of the contract and contract formation when we're looking at how am I going to escape a contract. So you want to be thinking about that when you're actually drafting. But one of the things that we're going to be looking at, the most common clause that I'm seeing written into these contracts, is what's called the termination for convenience clause. And usually the way that these are drafted is that there will be a notice plus some sort of wind down period, and then they will net out for any work performed, for instance. Now, those termination for convenience, you may draft them as one-sided, in your favor, but if you get into court, most likely the court is going to interpret them as a mutual provision. So really what you're thinking about at the beginning of this is, is this a contract that I'm not really all the way in on? Am I looking at other business or opportunities, and I'm just kind of entering this in case these other things don't pan out? And so I'm building in these escape valves, or these escape hatches in the instance that I want to be able to get out of it. Now, another thing that you'll see fairly typically is due diligence provisions. And due diligence provisions usually have time constraints or contemplated timeframes where you're going to complete these due diligence provision processes. And within those, you're also going to define who is going to complete what at what specific time. And so if if those things aren't meeting to your satisfaction, or you're still within the due diligence period and you haven't waived any other provisions, then you would still have that escape hatch. Now, all of these are kind of predicated on the idea that you're going to be able to avoid damages. And this is one of the things that Martin was talking about briefly. So one of the things he was touching on was these consequential damages. And he's absolutely correct that Oregon is a benefit of the bargain state. So in general, the only damages that you're going to get if there is a breach of contract is going to be for the lost benefit of the bargain, unless you've built in some other provision for damages into your contract. So for instance, you can build in a consequential damages provision. So you may be seeking lost profits, and that wouldn't be an ordinary flow from the lost benefit of the bargain to have lost profits. That wouldn't be necessarily foreseeable or obviously foreseeable. Another provision you may have is a liquidated damages provision. And that is an attempt to define actual damages. So it serves as a predetermined amount, and it's a compensation for the breach. And so as we're thinking about this in the contract sense, and we're going back to this idea where maybe we have this other contract that we might be entering into, but we have this liquidated damages provision that we've pre-drafted into the contract. You may do some math and figure out that if you have a new contractual opportunity come up to work with somebody else, it may be efficient for you to breach that contract and pay the liquidated damages provision and enter a new contract. But you need to do all of that math, and it may not be complicated, but it may be pretty in depth to get to the arithmetic of whether it makes sense to, whether it is efficient for you to breach that first contract, pay the liquidated damages, and move on to the next. So those are kind of those concepts. And I know it sounds kind of tricky and complicated, and that's kind of why lawyers get paid the way that they do. But it makes more sense as you start breaking down the various aspects of what you're trying to achieve within your particular project. And you say, it's kind of a choose your own adventure, if this, then this kind of a thing.
Okay. I think I actually get that one. And I can see that's possibly what a CEO would do, who's the head of this company with all kinds of stock options and everything else. And he decides he's going to go work for his competitor. He's going to efficiently breach that contract somehow. And it might be that the new company pays him a lot more money to help him pay for that damage.
Sure. That's right.
Okay. So, Martin, expert negotiator.
Yeah.
How do you approach negotiating settlement agreements or dispute resolution clauses to limit business risk, especially in tech and IP, where AI and rapid changes can lead to costly litigation?
So there was research done in 1923 about a new concept in negotiation. It was called empathy. And for years, I thought, oh, that's for life coaches, and it's not factual, it's not objective. But when you're at the settlement stage, something went wrong, right? Someone was hurt, there was a breach of contract, someone had damages. So you decided not to litigate, and you're trying to work out a deal to limit liability, limit risk of litigation, unknown costs, etc. And what I like people to do, and this is super effective, is three things. You open with empathy. What does that mean? Put yourself in their shoes and say something like, hey, and usually it's through counsel, but if before you get to attorneys, maybe you can say, hey, I know things didn't go the way you wanted. What are your thoughts? Things didn't go the way I wanted. What are your thoughts on what happened? And then you're going to let them talk. And you're not going to interrupt them. And afterwards, you're going to try to paraphrase what they said. That can launch a much more effective negotiation deal making than I want this, I want that. At some point, you're going to have to take off your combat gear and put on your deal gear. In other words, those are some of the things that you need to do. And if you ever read Never Split the Difference, Chris Voss, who's a hostage negotiator for the FBI, he's the same technique. You really have got to open with empathy. It sounds touchy-feely. You may feel a little bit vulnerable, but if you want to do a deal on your terms, and if you want to effectively communicate your needs to the other party, you got to open up with empathy. It's real, and it does actually have a psychological impact on neuroscience as well. And so open with empathy, listen, repeat to confirm what they said, and then you can get to the substance of the matter. I think the riskiest negotiations are when there's an asymmetry in negotiation expertise. When you have a highly experienced negotiator and someone who is, quite frankly, insecure, they haven't done it a lot. Or sometimes if you have a pure litigator against a pure deal maker, litigators, a lot of threats, will take you to court. This is not legal. All true, but we're in settlement. Can you, I mean, I've been in negotiations where opposite a younger litigator, and I think I counted 15 threats to litigate. But I can look at the numbers. I can look at the financials. There's not enough money here to litigate. So you keep, I know that's kind of a bluff. So more experienced negotiators, more experienced negotiators are more efficient. That's why I suggest you get people who know how to negotiate to head off problems in a protracted settlement agreement that should be pro forma. It should be a coming together.
Okay. Let's go back to you, Ryan, and talk about how we might reduce risk. I'm a small business owner. What's one high impact change that I could make to improve how I'm managing risk and approaching coverage?
Yeah. That's a really good question. One thing that business owners can do to make sure that they're appropriately managing their risk and getting the most out of their insurance coverage is really start with a focus review that asks more than anything, what exposures is our policy actually written to cover? Again, back to Blaine and Martin here, they can both appreciate that sometimes what's on the top page of a contract has really not much to do with what's down deeper. And so oftentimes if you jump into a policy and you get down into the small language and you look at the exclusions, you might find that it covers a business, just not your business. It might have never covered your business, or it might have covered your business 5 years ago. And so that's the first thing that really can take place. I wouldn't go it alone. I would get your broker and I would have them sit down with you and I would have them, perform a real deep review and then come back and talk to you about it. Have them help you ask smart questions so that you understand what your policy covers. And then where you find gaps between what your policy covers and what your business is, you need to shore those up. So, like I said, that's one thing that I'm a part of. Is I'm part of this team called a National Resilience or National Policy Resilience Analysis team. And at Brown and Brown, we take these big complex policies for our customers and we kind of hand them out to different people across the country that are unbiased. And they say, look through this, find the things that you think are problems. And it's not to create a Chicken Little situation, but it's again to make a list and say, if I had to rewrite this contract, there's 75 things or 15 things that I really don't like or I don't like a little. And then you order them like these top 5. I don't care what the customer is. These need to be changed. Then you dig in with the customer and you ask smart questions and you find out where the bodies are buried and you find out what they could do, might do, should do, never do. And then you start working on that list. Because again, as we talked about in negotiation, those things on the top, they need to get changed. But the things at the bottom, why not have them fixed? Why not ever worry about them? Just get them to use a different form or change the language. Mm-hmm. So that's really the one small thing I would say that a business owner can do to have a high impact change on their risk management is have their broker walk them through their policy and make them ask smart questions and make sure they know darn well what your business is and what your real exposures are.
I'm not sure if this next thing is going to only reduce my cost up front or and potentially reduce my risk or possibly increase my risk depending on that big print, little print. Mm-hmm. So buried in my emails, I have a thing from State Farm that says if I go take this online old driver's course, that I'll get a reduction in my insurance. I
Mhm.
suppose if I have fire insurance, if I have monthly reviews, I have a company coming in and checking all my fire extinguishers, and I do fire drills quarterly or something. That helps me. I expect if I have an anti-phishing campaign, that's going to reduce the cost if I have a cybersecurity breach. Yes, is it going to help me, or is there some small print that I might have in the contract that says, well, you paid less up front, you didn't do it, and we're not going to cover you?
Yeah, well, Paul, that actually kind of circles back to another point I was hoping we could cover today, which is that most business owners see their carriers as a cost and not as a partner, and that's a disadvantage. Um, your business partner, your insurance carrier through your broker, they don't want you to have a loss any more than you do. They will find a way to raise your rates if they need to raise your rates, regardless of if you have a loss. They're not going to have to do it as much if you don't have losses. So when you think about what your business is, understanding that your insurance carrier works with hundreds, if not thousands, of businesses like yours across the country, they are very in tune with the size of the building you have and the age of the wiring, the amount of employees you have, how big your auto fleet is. They can take that picture across the country and they say, these are the accidents that Paul is going to have. Paul's going to have a fire because he's got copper, he's got aluminum wiring. Paul's going to have an auto accident because he has too big of a fleet and no good fleet management system. And so they have tools that they want you to use that are available to you to help you reduce the likelihood of an accident. And those things might not necessarily translate to a discount on your policy the way that it is advertised in the consumer market, that it is bundle and save. But I'll tell you, not having a giant auto accident is a loss that won't be on your record a few years down the line when they're refiguring your rates, and it won't be an out of pocket loss that you're going to have by downtime, vehicle out, deductible paid. So I would say, if you're not talking to your broker about what types of tools your carrier is making available to you that you are already paying for, then you're leaving money on the table. Help them help you be a better, safer business.
Yeah, I want to add in a couple things from my experience being in product development in the corporate world and dealing with contracts and IP and something called recalls. So I'd like to add my own thoughts.
Yeah.
The end result that I often see in my areas of focus are damages, consequential and otherwise, injuries, deaths, and our government and the lawyers put a price on a life, and recalls. So product development deals with all of these results by proactively assessing, analyzing, simulating, and testing all kinds of things that can go wrong. I regularly read through a list of recalls for cars and trucks every month. It's often a bolt that was not heat treated correctly. A nut was not properly tightened by somebody on the production line. A hose or an electrical wire was routed incorrectly and it gets pinched or starts a fire. And recently, more and more in the last few years, software was done incorrectly, whether with AI software or not. And the main tool that engineers use for the product and for the manufacturing is something not called FEMA, same letters, but FMEA for failure, modes, effects, and analysis. It's a time consuming process involving many people from both product design and manufacturing and even service. And they have to try to look at every possibility of something going wrong, not just what they think and what they planned for, but something they might have forgotten. And it becomes contentious when a test guy suggests something that the product design person never thought, oh, that'll never happen. Well, it can. And so they assess, could it go wrong? How likely is it to go wrong? How dangerous is the result that comes from it? And then what can be done to reduce the risk? And we've got you multiply some numbers together and you get down to a level and you decide, okay, that's enough risk. Then you talk to the CFO and he starts putting some money aside for when something goes wrong that you didn't plan on. So as we're coming to a close here, Brian, quickly, come back to you. I've designed things wrong. I've had issues with suppliers in contracts. I've been in court due to contract language. Do you have any contract drafting tips to avoid litigation?
And that one is for Blaine, is that
For
correct?
Blaine, I'm sorry. Did I say someone else?
So yeah, the contract drafting tips, we touched on those kind of at the outset, and it's kind of it makes sense to talk about those again here at the end, because once the contract has been breached, what we're looking at, is the things like the position of the parties, so party size. I think Martin was kind of talking about this a little bit. So if you've got a Walmart versus a small business, Walmart's going to be more in a better position to litigate. You're going to be looking at who breached first. We talked a lot about damages. You're going to be looking at attorney fees, forum selection, whether there's an arbitration clause. And so if we're looking at those same things in the context of contract formation and drafting to avoid litigation in the first place, again, we're going to be looking at remedies. And we talked about this being a two-way street. Are we going to include consequential damages or not? Are we going to include liquidated damages or not? And then we're going to are we going to include defined terms for these provisions or not? Another thing we're going to look at is early dispute resolution. So I think that one thing that's important is to understand that we can draft these contracts in a step-by-step procedure. One thing Martin was talking about was how you can do out-of-court mediation to try and resolve the dispute before you might step into arbitration, which is also going to be before litigation. You can make arbitration binding or non-binding. You can make kind of a good faith discussion before you enter mediation required, that you get the decision makers in the room. So early dispute resolution language within the contract can help avoid litigation. The attorney fees being the double-edged sword, whether it's going to prevent litigation. If one side has a much better position and the other side's in breach, that may discourage litigation if you have that attorney fee provision in there. One thing I haven't talked about today that I want to touch on for a minute is early communication while the relationship is still positive. When you're at the beginning stages, when you're in the drafting stages, everybody wants to get the deal done. Everybody is interested, the interests are aligned, and everybody believes that the benefit of the bargain is going to be beneficial for their individual company. And it's at this time that it becomes imperative that the parties communicate about any potential ambiguities, or if anything's vague, if any of the timelines are undefined or unclear. This is the time when you're at the beginning stage. It's like being on a first date, right? That's the time to ask all these questions. Don't wait until you're married to start asking these questions when you've already completed the process. Ask on the first date when everybody is still really interested in getting to bed together, right? So do that at the beginning, define those terms, make it very clear. And if it's not clear, clear it out before you put it into the contract. And then one last thing that I talked about briefly at the beginning was, to the extent possible, I would recommend avoiding decision layers. So if you're having a decision by delegation or decision by committee or something like that, those types of provisions or those kind of committee decisions almost inevitably lead to additional conflict. The better way to do it is to have one decision point, one decision person that becomes the decider for whatever that decision tree point is, rather than having some sort of committee decision. So those are kind of my top 5 litigation avoidance drafting techniques.
Okay. Well, thank you all for participating today, and thank you for all of you listening and watching. Thanks for that thumbs up, Patrick, that I just saw. All registrants will receive a link to the recording of the panel discussion, as well as contact information for each of the panelists should you want to follow up with any of them. And with that, in the having watched the Edward R. Murrow play live on CNN this last week. In the words of journalist Edward R. Murrow, good night and good luck.